Welcome everybody to Morning Fuel. As usual, your cameras are turned off, mics are muted, so you can participate by asking questions through the chat feature, and we encourage that. I'm now going to turn it over to Brooks Simmons. He's going to introduce our star guest this morning.
Thank you, Mr. Chairman. Well, we're fortunate this morning to have a real friend of the industry, Attorney General Mike Hunter. Mike, you have done so much for the oil and gas industry, and I know as a young man you worked in the field. Can you remind us all as we get started here just a little bit about where you grew up?
Sure thing, Brooke. Good morning, Brooke. Good morning, David. And I appreciate the opportunity to visit this morning, and thank you all for participating via cyberspace. The origin of Mike Hunter began small farm in Garfield County, south of Enid, near Waukomis. I had the good fortune of, when I was in college at Oklahoma State, I had the good fortune of being able to work on weekends and holidays and breaks for my brother, who had a roustabout operation in Garfield and surrounding counties. Just about lost my thumb in trying to put a belt back on a motor for a pumping unit one day. So those are fond memories. The quick anecdote, I was catching up with Harold Hamm a few years ago, and as y'all know, he began his illustrious career in the industry in Garfield County and Enid. And as I'm reminiscent about that, he discloses that my sister worked for him 45 years ago. And he, talked about how pretty she was and how they had a hard time keeping guys out of the office. So I never knew that. And I confronted my sister subsequent to that meeting. Susie, why didn't you tell me that you used to work for Harold Hamm? Oh, honey, that was so long ago. Anyway, good memories. The industry has, in many ways, it's the thing that I attribute my opportunity to work for oil and gas companies at the Corporation Commission and doing title work in the 80s and early 90s. It really was a launching pad for my legal career, and certainly put food on the table. The position that I'm in here in the AG's office is if the Attorney General of a state, particularly if the Attorney General of Oklahoma isn't an advocate, isn't a champion for this industry, he or she is not doing their job. So it's a responsibility that I take very seriously, Brooke.
Well, we appreciate you. And I'd like to transition, if we can, to one of the most important issues, I believe, facing the state and certainly the industry, and that is the aftermath of the McGirt versus Oklahoma decision. You have spoken with us a number of times about the current lay of the land. Can you give us an update on the latest, and then we'll transition into that effort to tax some companies? What's the latest from your end?
So the latest is, just quickly, we felt like we had, it's been called an agreement in principle with the tribes to ensure that the McGirt case would not introduce specifically economic uncertainty. I mean, we knew there were going to be issues around criminal justice, which we're trying to deal with. Unfortunately, three of the tribes, just weren't able to stay hitched. I want to be respectful about all that. And we're kind of back to square one, or we were put back to square one after the agreement principle didn't stick together. Two of the tribes, I think, particularly with regard to criminal justice, have been supportive of our ability to get the congressional delegation to work up in Washington to give tribes the authority to compact with the state for criminal jurisdiction. So as most everyone knows, we've lost jurisdiction over crimes involving Indians, not Native Americans, in the Creek Reservation lands. And it is likely that there are going to be judicial determinations that reservations exist with regard to the Choctaw, Chickasaw, Cherokee, and Seminole historic lands. So we're very hopeful that we can close ranks with the other three tribes, get authority from Congress to compact on criminal jurisdiction, and the state can resume sharing concurrent jurisdiction with the feds and now the tribes with regard to crimes in Indian country, at least with respect to that part of the state. The commercial aspects of the decision, as we've seen with regard to the letter the Seminole sent to producers working in their historic lands, we saw the application of the Corporation Commission, in which a Native American-owned oil and gas company was attempting to escape regulation by the commission. So our office took the following approach to those two situations. We wrote the Seminole a respectful but firm letter with regard to our view of the law relative to their ability to tax and regulate oil and gas exploration and production on their historic lands in the event that it's determined to be a reservation. Brooke and David, we think the law is very clear. In fact, we're confident that the law is clear with regard to that. Tribes within a reservation can only tax or regulate if the non-Indians that they're attempting to exercise jurisdiction consent to that. That applies to contracts, and that is the principal way, and as far as we're concerned, the most significant basis upon which tribes can exercise jurisdiction. There has to be consent. With respect to the second part of that test, it's called the Montana Rule. If non-Indians begin to interfere with the sovereignty, the governmental activities of a tribe, they can respond to that by exercising authority and jurisdiction. There are two subsequent cases to the Montana case, again, the Montana Rule, in which tribes attempted, one case a tribe attempted to tax non-Indian business activity on a reservation. Another case involved a tribe attempting to regulate activities by non-Indians, commercial activities. Both those cases found that tribes do not have jurisdiction on either of those matters, either taxation or regulation on non-Indians. So that was the basis of our letter to the Seminole. Subsequently, that letter was withdrawn. I noted, and many of us have noted, that there wasn't unconditional. They made the remark at this time. My view of that is that, the tribe had to back down, and it's their attempt to, I guess, salvage, some dignity out of what I thought was a very ill-conceived and ill-advised approach to, where we go from here after McGirt. We are going to be participating in the defense of the Oklahoma Corporation Commission's decision with regard to the application of the company that I just mentioned. Corporation Commission found that the state does have jurisdiction. It's on appeal before the Supreme Court, and we're going to be involved in that process, again, defending the decision by the Oklahoma Corporation Commission. So the last piece of all this, which is problematic for the state writ large, is as a consequence of McGirt, what remaining jurisdiction does the state have on these reservation lands, both existing and about to perhaps come into existence? What authority does the state have to tax and regulate? And just for the record, I need to report to you that that is an uncertainty. And I wrote a letter to the governor and state leaders a while back, both emphasizing how important it was to get criminal jurisdiction back. But it's also important for the governor and the legislature and our office to begin the process of looking at compacts and ensuring that Indians on these reservation lands are going to participate as full citizens with regard to taxation and regulation. That has to occur via compact. And so our advice is, as soon as it is possible, we need to start working on those compacts, just so that we don't have uncertainty with regard to the Creek Reservation and these other reservations, which are, again, in our view, about to be activated in the very near future. So that's kind of an overview of where we are subsequent to McGirt. You know, simply put, it's a challenge for the state, and certainly a challenge for the tribes.
Okay. So let me ask a couple follow-up questions, one from the chat line. Have you heard of any other tribes that are attempting to tax oil and gas production or any other business? Have you heard any rumblings about that you can relay so that we can be on guard? And if our members receive notices, we should make certainly your office is aware of them.
I'm not aware of any efforts on the part of the other 4 tribes. My admonition to everybody participating this morning is, if you see that, if you hear that it's something in the offing, please contact our office. You know, our approach to all this is, we're confident what the law is, and we'd like to get these things resolved diplomatically, as we did with the Seminole. But there's just no reason for there to be an effort along these lines. We think the law is clear, and, you know, speaking for the tribes that I'm working most closely with, there's recognition that the law is clear with regard to that.
Okay. Now, with regard to the Supreme Court of the United States, the makeup is a little bit different now than when McGirt ruling came down. Do we view this as settled? Is there going to be any discussion about another case that might make its way to the Supreme Court that would change things, potentially?
So we continue to look at that. We're not dismissing the ability to modify the decision in McGirt. I don't think it's a given that the composition of the court is going to result in a different conclusion.
Mm-hmm.
We think the most practical approach, we think the most exigent approach is, number one, to get criminal jurisdiction restored via compact. Congress has to act. And then, with respect to the state's relationship with Indians on tribal lands, again, reservations potentially, we've got to get these compacts in place. So, you know, taking a couple of years with an approach to the Supreme Court, we just don't think is a practical and effective approach to getting these issues resolved. You know, I've been very clear with anybody that asks me my opinion of the decision. I'm not sure there's any more reckless, irresponsible decision by the United States Supreme Court. And, you know, Justice Gorsuch, as far as I'm concerned, wasn't listening. He and the other 4 justices, it's a 5-4 decision, weren't practical. The idea that you can displace 113 years of jurisdiction with a stroke of a pen and not pay any attention to the fact that you're potentially setting free violent criminals who happen to be Native Americans and who were charged and prosecuted by the state. I mean, that's the public safety disaster that we're all trying to deal with, those of us in district attorney's offices and our office. So again, I've been critical of the opinion. The imposition of reservation laws on a state in which 90% of the population on those lands are non-Indians just doesn't make sense. Yeah, you know, it makes sense certainly. For instance, on the Navajo reservation, where 90% of the inhabitants of the Navajo reservation are Native Americans. So it really has a potential, again, unless we roll up our sleeves and get this stuff addressed, to provide or to result in economic and social consequences which aren't in anybody's interest, Native American or non-Native American.
Great. What about any other risks sort of west of I-35 beyond the traditional reservation boundary lines of the 5 tribes? Have you heard about any sort of impact or similar claims or efforts on that side, western side of the state?
Well, I think, I don't want to be negative about my colleagues in the Oklahoma Bar Association, but there are some who are officers of the court who are attempting to apply the McGirt case to tribal clients on the western side of the state. Of course, the Chickasaw lands include several counties west of I-35, but we've looked carefully at the other tribal claims with regard to disestablishment. We're confident that this issue is unique to the 5 civilized tribes. So there have been efforts that we've been successful in heading off to apply McGirt to other tribes. So we don't see that having a realistic potential to create more problems for the state or more challenges, however you want to look at it.
Okay. Thank you very much for that. And as we conclude this, for the good of our viewers, we're going to be providing some direct contacts, not only for the association, but we'll make certain that we have an email address where, should members have received letters or something like that that would be concerning on this issue, that we can provide that information directly to your office, General Hunter.
That's great. Thank you.
Okay. Let me talk about one other state primacy issue, and that is regarding local ordinances and oil and gas regulation. You recall that we worked very closely with your office on some issues in Kingfisher County a while back. We know that we have several localities that frequently try to flex muscles, et cetera, on oil and gas, and that will have an impact not only for those companies that are working there, but also for mineral owners in the area. And I just want to see if you have any comment on that issue: state primacy for oil and gas regulation, not the jurisdiction of localities and municipalities.
Well, we think the law is very clear. We think that the primacy of the state and state regulators and the state legislature with regard to the regulation of oil and gas exploration and production is clear, and that counties and municipalities who attempt to circumscribe the state's authority there are doing so in a way that's inconsistent with the relationship of the state and its political subdivisions. Everybody understands on this, this morning as a part of this webinar, that you have to be good partners with cities and counties. And so I just think that there are situations where there are, I want to be careful here, there are political motivations here which sometimes get in the way of, again, being a good neighbor and a good partner. I mean, the companies I represented for 10, 15 years understood that, and I'm confident everybody on the call understands that.
Okay, thank you very much for that. I want to switch topics a little bit, and let's talk about some things that we're seeing occur in Washington, D.C. I think that it's pretty clear since January 20th that we're beginning to see an onslaught of executive orders, memoranda, and the reversal of the Trump administration's deregulatory efforts. And I know that there are 26 Republican attorneys general who are sort of serving as perhaps a backstop to some executive branch overreach. Can you talk to us a little bit about some of the conversations among your colleagues, or what you're sort of keeping a watchful eye on from the Washington, D.C. arena?
So I had the opportunity, Brooke and I both served sentences in Washington, D.C. in our past. And so I had the opportunity to work with Senator Biden's office and some with Senator Biden during that time. And, you know, one of the things that defined him as a United States Senator was his occupying a place sort of in the mainstream, very much a centrist. And I have to say, I certainly didn't support him in November, last November, but I have to say that I'm stunned with the approach that he's taken through executive orders, particularly given his admonition during the election that he was going to govern from the center and he was going to work towards consensus. But adopting the extreme positions that really are disconnected from reality and disconnected from what's good to for the body politic really are breathtaking. You know, the removal of the permit approval, the disallowance of the permit approval for the Keystone just flies in the face of safety concerns and what is practical. Those hydrocarbons are going to be transported to the United States from Canada. And the safest way for that to occur, you know, we're going to use rail, we're going to use trucks, but the safest way for those hydrocarbons to be transported is through a pipeline. And that is inarguable. For that to happen without consultation with Canada, and again, for that to happen based on the hyperbole of environmentalists, I'm really disappointed in. You know, the removal of permitting for offshore drilling and the disallowance of fracking to occur on federal lands. I mean, there are the impact of the economy, the impact that's going to have on the economy in states like Louisiana and Texas and New Mexico, which is a blue state now, is considerable and in a profoundly negative way is going to impact those states' economies. The jobs that we're going to lose with regard to those decisions. So there is not going to be much that moves through Congress that is consistent with that agenda. And so you can see signaling that the administration is moving quickly to try to advance that agenda. And it's literally a war on the oil and gas industry. Our position as Republican AGs, similar to the approach that was taken with Obama environmental extremism on issues like waters of the United States, Clean Power Plan, our approach is going to be that the executive branch has to operate within constitutional limitations. And so we're going to pick our battles carefully, but rest assured, on behalf of this industry, we are going to be vigilant and decisive with regard to how we engage on these matters. So we're having strategy sessions on almost a daily basis. It's important for us to be in close contact and in careful and thoughtful consultation with the industry as we engage on these issues. But as I said at the outset, an attorney general who doesn't support and champion and defend his state's or her state's economy just isn't acting consistent with the job of the chief legal officer of the state.
Great. I want to remind our viewers that we are taking questions through the chat function, so please use that function and we'll get your questions up. I want to say very much how very much we appreciate that effort, General Hunter, and defending Oklahoma's bedrock industry and its highly specialized economy. So we'll be looking forward to additional news on that front as you and your colleagues work carefully to sort of defend the industry. You mentioned earlier about our sentences in Washington, D.C. I want to point out for our viewers that you were twice the Oklahoma Secretary of State, Secretary of the Oklahoma Commission of the Land Office. You were appointed to the Attorney General's position in 2016 and won it outright in 2018. We got to be careful. People will think that you can't get a real job. But we want to also remind our folks that you're a good public servant. And on that front, I know that it's not too early for us to be thinking about what our candidate lists are going to look like in 2022. Being very careful with how you answer this, of course, but should we expect to see your name on the ballot for reelection?
Well, that's the plan. We do have a candidate committee for 2022 that we stood up before the first of the year, and you know, this is kind of a I'll call it a presentation that's limited by me being in an official capacity this morning. So that's all I'll say. I do intend to seek reelection in 2022. I have formed a committee, but I am going to recuse from saying anything else about that.
Well, we appreciate that, and we appreciate the guardrails that are around that conversation this morning. But again, we would be remiss if we didn't ask that question.
Thanks, Brooke.
Are there any things regarding any of the issues that we've discussed today that you want to bring up, or things when Mike Hunter is lying in bed trying to go to sleep at night that he really thinks about when it comes to Oklahoma's highly specialized economy, things that trouble you the most, the challenges that you see over the horizon? Can you talk a little bit about just how you see the landscape in Oklahoma moving forward?
Well, the challenges that this industry and the state is going to have to address, I think principally exist and loom outside our borders. There continues to be vapidity and a lack of understanding about how critical it is to look at, you know, whether it's climate change writ large, you know, whether it's sort of a blind approach to bringing emissions down in the United States. Oklahoma is responsible, the United States is responsible for less than a fifth of the carbon emissions globally. And so for us to essentially disarm our economy while China and India and Russia are carrying on with business as usual, I mean, it is a threat to our country's national security. And so now, while we've been able to establish energy independence, and we can't be held hostage by OPEC or other oil-producing countries to essentially abandon the victory that we've won with regard to energy independence, just isn't responsible, and it's inconsistent with national security. So, you know, I'm happy to talk about a measured approach. I think the industry has done great things with respect to being responsible about the environment. So again, it would be great if there was a way to speak and to discuss the issue without things being so polarized. Mm-hmm. But my experience with folks who get up in the morning, go to bed at night, for whom, you know, protecting the environment is almost a religion, you just can't have a conversation that's a give and take, where the positions are being respected and the contributions and the importance of our industry is essentially being ignored, based on this utopian view that we can, you know, have an economy and have energy sources that we rely on that don't include oil and gas. So that's the concern, I guess, that keeps me up at night is, again, this mad sprint towards, you know, some level of emissions that the United States takes on while we ignore the largest polluters on planet Earth.
Hey, Mike, what's in our legal toolbox to defend ourselves from mandated regulations coming from like the EPA? What can we do? You know, the governor of Texas did an executive order to defend and all legal from all legal aspects, all the agencies that defend the Texas's oil and gas and energy business. What kind of toolbox? What's in our toolbox to defend ourselves from? We got things like methane emission drones that are in the air now, and things like that. What can we do about that, if anything?
Well, the executive branch, the executive branch in issuing executive orders, in their, management of the environment, has to work within the confines and the limitations of the United States Constitution. And so that was the approach that was taken by Republican AGs during the Obama administration when rules were being promulgated that were inconsistent with black letter law. And so one of the most important limitations on how bureaucracies, how federal agencies can act is their rules have to be consistent with, they have to be complementary to and authorized by black letter law, by statutes, federal statutes passed by the United States Congress. And so there was good success in challenging a lot of those rules that completely departed from any kind of statutory authority. Moreover, there has to be attention to a Supreme Court case, which there are cases pending that would hopefully overturn the case. It's the Chevron case, and the decision was years and years ago. But the Chevron case grants this deference to this presumption that federal agencies who promulgate rules do so in a way that's consistent with their statutory authority. And so although that's been an impediment, and it's an uphill climb when you're challenging an agency rule, we've been successful in a lot of courts around the country in those challenges. So if there's an important legacy from the last 4 years, it's the number of federal judges who are going to be restrained and respectful of the United States Constitution that have been appointed around the country. And that gives me a lot of hope, David, as we deploy in states around the country, that we've got judges that are going to follow the Constitution and not sit as legislators and chief executives.
So just to take that a little bit further, so the Chevron ruling pretty much preserved the status quo as far as overstepping what statutes are currently in place for these bureaucratic bodies. But right now, the environment in Washington is such where those laws could be rewritten or amended. How do we stop or how do we defend ourselves from them basically rewriting the rule book, which seems like to me to be the repetitive serial actions that are being taken by the Biden administration, Democrats in general.
So the margins in the House and Senate are razor thin with regard to the Democrats have, I think, a 10-seat majority in the House. At least 5 of the members of that margin didn't support the Speaker in her re-election efforts. The Senate is a 50-50 split. I think that the role of the Vice President in Senate activities has been overblown. The Vice President can only vote if there's a tie. There has to be a 50-50 tie for her to vote. She can't vote if one Republican senator or one senator is absent to give a majority on the floor of the Senate. Moreover, I mean, just to talk about personalities for a second, Joe Manchin, the Democratic senator from West Virginia, has already, I think, in a very public way, distanced himself from the approach the president has taken to the environment. And so I have high confidence in Joe Manchin representing West Virginia's interests in the United States Senate on votes like that. So there is not a majority in the Senate, as far as I'm concerned, and it's arithmetic, it's not calculus, that would support any kind of environmental legislation that is, again, consistent with the agenda of progressives on the issue of environment and climate change. So the Senate, in many ways, although because of the vice president, the leader of the Senate now from New York is going to set the calendar and the agenda, but I don't see how they get votes to move anything that's going to be meaningful and harmful, rather, is a better word, meaningfully harmful maybe to the industry.
Do you think that observation plays forward with potential elimination of filibuster, court packing, gerrymandering, and adding judges, more liberal judges? Does that play forward, or do you, as far as this kind of stalemate?
I think stalemate's a good word, David. The real test is going to occur in the 2022 elections, and there's going to have to be great attention to that. We have some people, again, I'm being political here this morning. We are going to have some open seats, we being Republicans. Rob Portman's not running in Ohio. It's going to be tough to hold on to that seat because Congressman Tim Ryan is apparently going to be a candidate. Let's see, United States Senator from Pennsylvania, Pat Toomey, I think, is not running. It's going to be tough to hold that seat. So there's got to be, there's got to be great focus, and there's got to be commitment as we move into the midterms to ensure that we don't end up with a Congress that's going to be able to move what I believe, and I'm sure many with us this morning, is a radical agenda that's not in the best interest of the country. There was a strong signal sent with respect to particularly elections in the House. The majority the Democrats have in the House is razor thin, and that's a result of a lot of, as far as I'm concerned, Americans waking up to the fact that having a progressive agenda that's inconsistent with capitalism and free enterprise in Congress is not something they're supportive of. So the midterms are going to be real important. I'll echo your word, stalemate. That's how I see the next couple of years. Frankly, I think it's going to be essentially a status quo. We're going to do our best to ensure that the executive branch doesn't act outside its constitutional limits. But I'm concerned about the last 2 years of Biden's term.
Some of these executive orders, or most of them, have a really short tenor to them. I think that, wasn't the XL pipeline only 60 days or something like that? So this isn't over, right?
No, it's not.
So, General Hunter, we really do appreciate you being on this morning. Mr. Chairman, do you have any other questions or any other comments before we sort of move to clean up and forecasting about the next morning fuels?
Other than I certainly appreciate you being on, Mike. It's really
Sure.
helping our folks. We've had a lot of time. This is a very timely event to have you on, because everybody is concerned. Anytime there's not a decision made on anything, uncertainty is not. It's hard to plan budgets around uncertainty. So thank you for adding some clarity for us this morning.
Uncertainty is sand in the wheels of commerce.
There it is.
So I appreciate David and Brooke. Thanks for having me on. I appreciate the industry support. I've never apologized for being a champion of the industry. I ran for this job back in 1994 and was unsuccessful. A lot of you supported me. I guess I'm just sorry that it took so long for payout to occur.
Well, we appreciate you, sir. Thank you very much for joining us this morning. And I want to remind our attendees that the Alliance has set its 2021 events calendar. The information can be found at thepetroleumalliance.com, or look for the Alliance highlights email every Friday. I also want to remind folks that our next Morning Fuel will be Wednesday, February 17th, with Bitco Insurance Companies, who will offer a presentation on understanding DOT scores and how they impact your company. And on the topic that we discussed today, on February 24th, we're going to tackle McGirt versus Oklahoma again, when we're joined by the law firm of Ball Morse Lowe to discuss contract modifications in Indian country. Folks, you do not want to wind up in tribal court, so pay attention to that one. So with that, General Hunter, Mr. Chairman, any final comments?
Thank you for attending, guys.
Thank you all.
Appreciate you. Thanks very much, everyone, for joining us today. We'll see you next time.